Short overview of steps and procedure. To understand the steps involved in getting patent for your invention in more clearer way, let's assume three illustrations as below. First, you, the inventor, who has innovative idea to file patent. Second is the illustration for patent professional, which is a patent agent or patent attorney. And third is patent office, that is a controller, examiner and other staff. We would be seeing what is the involvement of each one of them at every step while getting patent. Along the way, we would also be seeing the relevant forms and costs involved at each stage. So let's get started. Step 1. Idea incubation phase. Every invention has its beginning in an idea. In this phase, you capture your idea properly, get clarity on each element of innovative idea, do fill in the blanks. Any blank spots in your idea, you can do a research, appropriate research and experimentation to fill in with the details of that particular blanks. Include drawings, diagrams or sketches explaining working of the invention. The drawings and diagrams should be designed so as to explain the working of invention in better way with visual illustrations. They play an important role in understanding your invention. Once you have your innovative idea completely captured with all technical details, then you perform a preliminary search. Now this search is performed for finding answers to questions which builds a working invention disclosure. So let's see some of the questions in invention disclosure form. What is my idea or invention is about? How does it work? What problem my innovative idea is solving? What is the field of my invention? What are the advantages of my innovative idea? What are the elements or components of my innovative idea? Can I draw a block diagram or a device or a flowchart or a sketch that explains my idea in a better way? What are the advantages of my invention over existing knowledge, that is prior arts? Who are the competitors in the market? With what product or what service, etc. For this important section, we have a complete chapter about actions to take and worksheets. Refer to chapter number 2 on idea incubation phase in this workbook or information series. Now let's consider the involvement. You as an inventor has 100% involvement as you are whole and soul working on your idea. The patent professional is not involved yet and even the patent office is not involved yet. So the involvement is 0% for both of them. Costs. There are no costs involved at idea incubation phase because the idea and the invention disclosure still is with you. You haven't taken any further action with related to filing or anything. The outcome of this idea incubation phase is creation of working invention disclosure which covers all aspects of your invention completely and which is ready to be shared with patent professional. Step number 2. Patentability search. Now this is an optional step. In this step, the patent agent or attorney who is working on your invention helps you in finding out whether your invention meets all patentability criteria, which are novelty, non-obviousness, and industrial application. The patentability search is aimed towards finding out the novelty and non-obviousness of the invention. The search identifies the closest possible prior arts, that is something known to public, and based on the results obtained, an opinion about patentability of your invention may be provided by patent professional. Based on the results found and reviewed in patentability search report, the patentability opinion may be positive, negative, or neutral. A positive patentability opinion indicates you stand a very good chance to get your patent granted for your invention. The patentability report and opinion helps you decide whether to go ahead with patent or not. Chances are, what you thought as completely new and novel idea might already been patented or known to public in some form of information. Hence, this report saves a lot of time, efforts and costs of yours as an inventor by helping you decide whether to go ahead with patent filing process or not. For more details on this important section of patentability search, refer chapter number 3 on working with patent attorney in this workbook or video information series. Now let's consider the involvement. In this patentability search, you as an inventor have 30% of involvement. That is about answering to questions by patent professional, reviewing patentability search report and closest possible prior art from technical side of it. The patent professional has 70% involvement as he has to understand the invention disclosure completely and perform the exhaustive patentability search or comprehensive patentability search and prepare the report and give opinion on patentability. The patent office has 0% involvement because it is not involved as of now. Costs. The professional fees for patent professional to perform a patentability search can range from 10,000 rupees to 30,000 rupees for performing a patentability research. And the time required for this is about 5 to 7 working days. However, in some cases where the invention is not that difficult or not that complex, the patentability search could be done in less than 5 days also. The outcome of patentability search. You get to know the opinion on patentability of the invention. Now, in and itself, this is the most important outcome you can have. The inventive step and novel feature of our invention is identified when our invention is compared with closest possible prior art found in the patentability search report. The patentability search report would give you overall picture of state of the art, that is current stage of the technology, and you might find some white areas where you can do further research and development. The inventive step identified via patentability search can be leveraged while writing patent application and especially claims for patent, such that our patent application stands a very good chance of going through the examination stage to be granted patent. In case the patentability opinion is negative, then it saves a lot of cost and time which would have unnecessarily be invested in proceeding with patent filing process and eventually getting application rejected. Note, in spite of all these benefits of patentability search, this is an optional step. You can choose to directly file the patent application without going for patentability search, which is not recommended by the way. Step 3. Patent drafting or patent writing. Patent drafting is a stage where your invention disclosure and patentability search report is used to create the patent application. Patent drafting or patent writing is a specialized job. It requires years of practice and experience with patent law to draft a good patent application. To get an idea, just read some granted patents from your domain. Patent is a techno-legal document. There is a technical side as well as legal side to it. So most common mistake done by do-it-yourself or done by inventors writing their own patent application is writing a patent as project report or a technical thesis on your own and submitting it to patent office would be a mistake which can cause loss of opportunity to patent your invention. There are many rules and cares to be taken while drafting claims, writing detailed descriptions, writing different embodiments for the invention, describing inventive step. This is one of the most important step in life cycle of patent, and a good patent application written by an experienced patent agent or attorney should survive not only through examination phase till the grant of patent, but also it should survive the commercialization phase, which is the most important for us as an inventor, that is making money with our patented invention, where actual money is made by licensing or selling patent rights, where competitors should not be able to work around your patent. Now, writing such a patent application is a skill, and that's what explained in detail in our section on preparing patent application, that is patent drafting, in chapter number 3, that is working with patent agent or patent attorney. Now let's see the involvement. In this phase, that is drafting patent application, you as an inventor have 10% involvement about answering questions by a patent professional, identifying the inventive step and providing detailed disclosure if required, and review patent application. The patent professional has 90% involvement for writing patent application that provides maximum possible protection to your invention. And patent office has 0% involvement as it is not yet involved. We haven't filed the patent application yet. Costs. The professional fees for patent professional can range from rupees 25,000 rupees to 40,000 rupees for drafting a patent application. The time required for drafting a patent application is about 8 to 15 days, and this is based on the complexity of the invention. The outcome of this step. The outcome of this patent drafting stage is a completed patent application that can be filed to patent office. A patent application well written by experienced patent agent or attorney that survives through examination phase till the grant of patent and commercialization phase. Step number 4. Filing patent application. Filing patent application into patent office. Based on the readiness of your invention, the decision has to be made whether to go for provisional patent application or a complete patent application. If you are not quite ready with complete invention and require further research and development, yet you don't want to lose on priority date for filing patent application, then going for provisional patent application is recommended. There are many advantages for filing provisional patent application, which are discussed in detail in a separate chapter about filing patent application. In that chapter, we will be seeing when to go for provisional patent application, what are the advantages, what are the costs, elements of provisional patent application, and mistakes to avoid while filing the provisional patent application. As patents are territorial in nature, so if you are filing patent in India, you are getting protection in India only. You cannot stop use of invention outside India then. Therefore, if you desire that your invention should be protected in multiple countries, depending on your preference of countries, different options, paths and strategies for filing patent application is to be adopted with the guidance of patent agent and patent attorney. Now for international patent application, different options and routes are available, strategies to go about international patent filing, the PCT application, the Paris Convention and other routes. Now as this is a short overview of the process, the details about patent filing is explained in chapter number 4, that is filing patent application. Let's look at the involvement. You as an inventor have 10% involvement about reviewing the patent application, signing formalities like forms, power of attorney to submit along with the patent application. The patent professional has 80% of the involvement for preparing patent application for filing, recommending best filing route and options for international patent application if required, and submitting relevant forms and fees in prescribed manner. The patent office is now involved with 10% involvement to receive the patent application and provide the receipt along with the date and time of filing the patent application. Costs. There are no professional fees for patent filing. Government forms and fees. The relevant form for patent application is Form 1. And regarding fees, there are many things needed to consider before giving exact fees amount, as it depends on number of sheets in patent specification, number of claims, etc. But below are approximate costing for this stage. Application for grant of patent. Individual inventors 1600 rupees. Small entity 4000 rupees. Other than small entity, that is large companies, 8000 rupees. The time required is less than 1 day if it is filed online. The outcome of this step. The outcome of this filing patent application is you receive a receipt for filing patent application in government patent office with invention title, your name along with the time and date for filing. Now your invention is safe and you have secured a priority date for your invention, which makes you less worried about confidentiality and safety of your invention. The patent application will be taken to subsequent steps if you submit the forms, request and fees as per standards. Step number 5. Publication of application. Generally, the application is automatically published after 18 months from the filing date. No fees or action is required by inventor. But if you don't want to wait till the expiry of 18 months, an early publication request can be made along with the prescribed fees. The early publication request can be made, which is an optional step of course, with Form 9 and by paying prescribed fees as per table below. In general, the patent application is published within a month from the request for early publication. Let's see the involvement for publication of application. You as an inventor have 0% involvement on automatic publication, or optionally you can file early publication request along with Form 9 and fees. The patent professional has 10% involvement, optional step of filing early publication with Form 9 and fees. The patent office has 90% involvement. The patent application is automatically published, or if requested, early publication is done. Government forms and fees. Form 9. Remember, there is no fees for publication of application automatically after 18 months of filing date. The fees mentioned below is for optional step if you want to go for early publication request. So the fees here is, so request for early publication, as an individual inventor you need to pay rupees 2,500. As a small entity it is 6,250, and other than small entity it is 12,500. Step 6. Request for examination, RFE. The patent application is examined only after receiving request for examination, that is RFE. The inventor or applicant need to file a request for examination, that is RFE, within 48 months from the date of filing or the priority date. This request for examination is made with Form 18 and the government fees for the same is mentioned below in the table. Upon receiving this request, the controller gives your patent application to a patent examiner who performs searches for checking patentability of the invention as per patentability criteria, and then the examiner creates the first examination report, that is FER, of the patent application. The first examination report submitted to controller by examiner generally contains the prior arts, existing documents before the date of filing, which are similar to the claimed invention, and any objections raised regarding patentability requirements for the invention. Same examination report with objections is communicated to you, the inventor, or the patent applicant. Let's see the involvement. You as an inventor have 10% involvement. The patent agent or patent attorney makes a request for examination on behalf of you, or the request for expedited examination with Form 18A if applicable. Patent professional has 10% involvement, that is request for examination is submitted with Form 18 and fees, or a request for expedited examination with Form 18A if applicable. And patent office has 80% involvement in this stage, receiving the request for examination, and examiner checks patent application for patentability and other criterias and generate first examination report. The government forms and fees. The form is Form 18. The fees for request for examination, that is RFE, is as below. The request for examination, individual inventors 4,000 rupees, small entity 10,000 rupees, other than small entity 20,000 rupees. Step 7. Response to objections. Majority of patent applicants, that is inventors, will receive some type of objections based on examination report. Analyze the examination report with patent agent or patent attorney and create a response to objections raised in examination report. This is a chance for an inventor to communicate his novelty and non-obviousness of the invention based on the kind of objections raised. You as an inventor or applicant supposed to answer the objections raised within 12 months from the date on which the first examination report is forwarded to you. The inventor and patent agent or patent attorney create and send response to objections that tries to prove to controller that his invention is indeed patentable and satisfies all patentability criteria, or optionally accepts the objections and amends, that means changes, the patent applications as pointed out in first examination report. If the controller is satisfied with the response to the objections or the amended patent application, and upon finding the patent application in order of grant, the patent is granted to you as early as possible with a seal of patent office, and the date of grant is registered in Register of Patents. Involvement. You as an inventor have 30% involvement to help patent agent or attorney in technical matters of invention if required for drafting response for objections. The patent professional has 40% involvement to draft the response to objections raised with the help of inventor, that is you, or amend the patent application accordingly, or request for hearing if desired. The patent office has 30% involvement, which receives the response of objections and decide whether a hearing is needed and whether to grant a patent or not. Professional fees. The patent agent or attorney may charge professional fees to respond to objections based on the complexity of objections and number of objections received. The fees for response to objections varies from Rs 6,000 to Rs 25 to 30,000 depending upon complexity, subject matter and number of objections. Step number 8. Grant of patent. The application would be placed in order for grant once it is found to be meeting all patentability requirements. The patent is granted to you as soon as possible with the seal from Patent Office, and the grant of patent is notified in Patent Journal, which is published time to time. Involvement. You as inventor 10% involved. Patent is granted to you as per section 48. You get right to exclude others from using, selling, offering for sale or importing your patented invention. Patent professional have 10% involvement. Inform inventor about procedures, renewals and communication to Patent Office after the grant of patent. And Patent Office has 80% involvement to decide grant of patent for invention or reject the patent based on the response to objections raised. Notify the grant of patent in Patent Journal. Let's look at the complete flowchart of idea to granted patent. Now this is a comprehensive flowchart. It starts with idea incubation phase, then filing the patent application. There are two options, whether provisional or complete. If you file provisional patent application, you need to file complete patent application before the expiry of 12 months from the filing of provisional patent application. If not, the provisional patent application would be abandoned. The application is published as per section 11A after 18 months from the priority date. In the next phase is request for examination, which is made with Form 18 and within 48 months from the priority date. Then there would be pre-grant oppositions, if any, and then examination of application. The first examination report is issued and which would be communicated to inventor as well as patent attorney. If the objections in the first examination report is not met within 12 months, the application stands abandoned. If the objections are met within 12 months, the patent is granted to you. And then we have post-grant opposition.